Swayam Prabha. Digital India. Educated India.
Hello students, we are continuing our discussion on jurisprudence and Indian legal system. In this lecture, which will be on legal services and Lok Adalat, we will try to understand some other dimensions of the jurisprudence and this legal system of India. What would we learn in this lecture? In this lecture, we will learn the constitutional mandate for the legal services. We will also learn the efforts of the Supreme Court of our country for providing the legal aid. Then we will also see the advent of public interest litigation, and thereafter we will see the legal services legislation, and after that we will also try to understand some cases pertaining to legal services and also maybe on Lok Adalat. We will also look at the BNSS provisions, the latest law on it, and thereafter we will take up ADR, alternative dispute resolution, and how the Lok Adalats are important and they are falling in one of the ADRs. Finally, we will look at the role of the bench and the bar in providing the legal services. First of all, we should try to learn about the constitutional mandate for the legal services. What is the constitutional mandate? Our constitution is one of the very important documents as far as the jurisprudence is concerned. The jurisprudence of our constitution provides that there are certain values, there are certain principles which are very important. And the legal system of our country also is based upon certain principles and values. I have discussed with you some of those principles like the rule of law principle and also the separation of powers principle. In this lecture, we will try to learn about another principle, another value which is called access to the justice system, access to the legal system, and therefore, if the accessibility is not there, if the access to the justice delivery system for the people, for the common people will not be there, then even if the legal system is very technical, but it will not be helpful for the common people. Therefore, it is one of the core principles of any legal system that it should provide accessibility, easy accessibility to all the people of the country or for the legal system. So, our constitution, when it was drafted, at that moment of time, the drafters of the constitution, they also knew that we should try to have this principle incorporated in the constitution. At that moment of time, they had thought that giving the fundamental rights to the citizens, that will be very important and that will give access to justice. And therefore, you might have known that some of the articles like articles 14, article 19, article 21, 22, 32, 226, 39A and 51A, these are some of the provisions which have been there. But during the drafting of the constitution, 39 capital A and 51 capital A, those were not there. During those times, all the fundamental rights relating to the right to life, right to freedom of speech and expression, right to equality and right to be informed when there will be arrest. Now, these were the provisions which were there, and the drafters of the constitution, they thought that this will be enough to give access to the delivery system of law, the justice delivery system. However, the provisions were there, the fundamental rights provisions were there, but the people, they could not access the justice delivery system, because of the fact people of the country at that moment of time were very poor. Lot of poverty was spread all over the country, as you might have known that the Britishers, when they had ruled our country for the last 200 years, they had drained the wealth, and the country which was called a golden parrot country, but this had become just a country having people having hunger and poverty. So, this was the reason why the constitution made the fundamental rights very important. This was the chapter 3rd of the constitution, in which it was laid down that the individuals, the citizens, they can enforce their fundamental rights by filing writ petitions in the courts, particularly the high courts and the Supreme Court. Under Article 32 of the constitution, the Supreme Court is having the power of writ jurisdiction, and any citizen who has been the complainant, if there is any kind of violation of the fundamental rights, then a citizen can directly file the writ petition before the Supreme Court. Likewise, if a citizen's fundamental rights are violated under Article 226, then a citizen can file a writ petition in the high courts. So, these were the provisions, and the drafters of the constitution, they thought that this will be enough for them, for the citizens to get justice and their fundamental rights will be protected. However, I told you that because of the poverty, the people could not even go to the high courts, and the people, the common people, the people who were poor, they could not go to the Supreme Court. Now, in that case, what will happen? In that case, whether the provisions which were there in the constitution, whether those can be simply, if they will be given meaning, then whether poor will be having access to the courts, to the high courts and Supreme Court. Now, that was very, very difficult, and therefore, what we will see that the Supreme Court had to start some initiatives, and one of the thing that was done, that was the acceptance of public interest litigation. Now, you might have heard about public interest litigation, where if there is an interest of the public and the litigation is relating to the public interest, then it is not essential that the person who is the victim, that person will go to the court. Normally, the jurisprudence has been that if a person who wants to go to the court must be the victim of some harm which has been caused by others, and then that person goes to the court and asks for justice. But if the person is not a victim, in that case what will happen? Whether there will be no justice, and why the person is not going? Not because he does not want to go, not because she does not want to go, because she is so poor, because the person is so poor that he knows that going to the court is not simple, and it will take economic burden on the person, so to reach the courts. And therefore, what was the reason that many people, they could not go to the court, even though they were suffering from some harm caused to them. And therefore, when this was the fact, the Supreme Court had liberalized the standing in law. This is the term which is technical term, we call the standing in the court. What is the standing of a person in the court? So, this is called locus standi. How this locus standi principle, which is one of the important principles of the traditional jurisprudence, that one who goes to the court must have the standing in law. Now, this standing in law meant that you must be a person who has suffered harm, who has suffered injury from the acts of others. Now, if this would be the traditional jurisprudence which will be accepted by the Supreme Court and the High Courts, then what will happen? That the poor people, they could not go to the court, because even if they have suffered harm and they have been injured, but they could not go to the court because of poverty. So, if this rigid rule of standing would not be changed, then how there would be access to justice? Although the constitution, the drafters of the constitution had inserted article 14, article 15, 16 and 19, 21, all these high sounding articles were there, but on the ground this was not proving effective, and therefore, what happened? That Supreme Court relaxed the rule of locus standi. We will see that how the rule of locus standi was relaxed. There are certain cases which must be understood. Let us try to understand a very leading case, that was called Hussain Ara Khatun case. Hussain Ara Khatun case is a landmark judgment of the Supreme Court of India, and this was decided in 1980 by the Supreme Court. The Supreme Court judges, Justice P.N. Bhagwati, you might have heard about that judge, and he is considered to be a very prominent judge of the Supreme Court during the late 70s and 80s. And Justice P.N. Bhagwati with Chinnappa Reddy and Justice A.P. Sen, they stressed the necessity of a nationwide legal aid program to provide free legal services. Do you know why? Because the Hussain Ara Khatun case, in that case what happened, that a lady who was sitting in Delhi, she was an advocate and a very prominent advocate, and she was just going through the newspaper articles, and one of the newspaper news was that many under trial prisoners are suffering in the jails of our country. One of them was Hussain Ara Khatun. That story was running that Hussain Ara Khatun, one of the under trials, she was there, one of the jails of Bihar, and she was languishing. She was the only bread earner of her family, and still she, because of some petty offense that she had committed, she was arrested and she was put in jail. The trial was going on, and ultimately she could not see that when she will be free from the jail and she will go back to meet her family members. But what happened, that she was still there. Why? Why she could not be released from the jail? Because she was so poor, she could not have the capacity to afford any lawyer. She was dependent upon the state, and the state could not do anything, and therefore, she was unrepresented. The legal services were not provided properly to Hussain Ara Khatun, and likewise many other under trial prisoners all over the country, they were having the same plight. So, this was the news article which was published by one of the prominent newspapers in the late 1970s. And when this newspaper was read by that lady advocate of the Supreme Court and High Court sitting in Delhi, what she thought, that can I do something? Now, we all read newspapers every day. We always look at the news on our mobile and tabs and computers, but how many of we are not simply moved, but also want to do something for that? Now, that was a lady advocate. She wanted to do something in this case, and you know what she did? She filed a writ petition in the Supreme Court on behalf of those under trial prisoners who were languishing in different jails of the country. And not only that, she filed the writ petition, but she was not the person who had suffered injury. She was advocate sitting in Delhi. She was not the person on whom there was a charge and she was in jail, and she was not released. But what she was an advocate. She could not have done it, but she did it and she filed the writ petition. Not only that, she prayed to the court, Lordships, please allow me to take up the case even if the person has not come. There is no wakalatnama signed by me and her. Still, I want that her case must be heard, and she was praying to the court that the rigid rule of locus standi must be relaxed. And you know what? Supreme Court was moved by the argument, and Supreme Court said that if this kind of public interest is there, she was saying that this is a public interest, this is not my individual interest. This was a public interest, and therefore, the public interest must be heard. Who will hear the public interest? The Constitution enshrines Article 21, right to life, and how this right to life will be fulfilled if a person is not going to meet his or her family without seeing that when the trial will be over and the trial is going on, even the magistrate is not saying that, okay, if a person is unrepresented, what will happen. So, in that case, she was praying to the court that let the rule be relaxed, the rule of locus standi may be relaxed, and you see that lady was Kapila Hingorani. And Kapila Hingorani, sometimes lawyers do marvelous things, and this was the example of a lady advocate in the late 70s who moved this petition in the court, and this petition was considered as a public interest litigation, and Hussain Ara Khatun became a very important judgment, and the court also said that yes, there is a need of nationwide legal aid program, and what will happen? This legal aid program will provide free legal services, and the court linked it to the existing articles of the Constitution, like Article 14, like Article 21, and then you see that Article 39A had also come. You might remember the amendment in the Constitution by the then Prime Minister of the country. What she was doing, Prime Minister Indira Gandhi, what she was doing, that she had started a nationwide program with the slogan Garibi Hatao. So, that poverty removal program which she had started, in that program you see how this poverty, she was knowing that poverty is a hindrance to access justice, and therefore, Article 39 capital A was inserted in the chapter 4 of the Constitution, and Article 39 capital A was saying that the state will provide free legal services, legal aid, and there will be access to justice for the poor. So, all these provisions, Article 14, 19, 21 and Article 39 capital A, including all these principles, they helped the Supreme Court in deciding the judgment, and that judgment is called Hussain Ara Khatun judgment, which is very important. Next in line of the case which developed the jurisprudence of relaxing the rule of locus standi and then giving more accessibility to the poor people was Khatri versus State of Bihar. You might have heard the famous episode of blinding, Bhagalpur blinding. There is a town in Bihar called Bhagalpur, and in that town what happened, that the jail, which is a central jail, in that jail what happened, that the under trial prisoners were there, and what happened, that some of them, they were blinded by some of the people who were there. So, this was a kind of acid attack on the under trial prisoners, and you know what, that this came again in the newspapers, this was flashed all over the country, that what is happening in Bihar, people who are in jail, they are thrown acids in their eyes and they become blind. Is this the plight of the people who are poor people? When you go in jail, you will find that there are many poor people in the jail, and this is a very difficult situation for anyone when someone goes to the jail and finds that people who are there are mostly poor. Now, Khatri versus State of Bihar, what happened that when this Akpurva Kand or the blinding of eye case, that was again published by the newspaper articles, and then the court again was having the opportunity to look at it, because again the writ petition was filed that what is happening in Bihar, why not the Supreme Court will do something. And you know what, that the Supreme Court asked the government of Bihar, the secretary of the province Bihar, that what is happening, you see why the people are getting such kind of treatment by the state officials, and in this case the officials of the state were also involved in the blinding of the prisoners. So, in this case what happened, that some of the directions which were given on the free legal aid were, first was that the magistrates obligation of the magistrates, the court said that the magistrates and the sessions judges must inform every accused who appear before them if they are not represented, due to poverty, and that they were entitled to free legal aid at the state's cost. So, earlier what was happening, that sometimes the states will say that no, we do not have money, how can we provide lawyer to everyone who is under trial. So, the court says in this case that no, this is the duty of the state to provide the legal aid at the state's cost. And the court recognized that 70% of the rural individuals are illiterate and unaware of their legal rights, and therefore, the court emphasized that leaving the request for legal aid to the indigent accused makes legal aid ineffective, and therefore, the court says that this is the state's responsibility, that they should provide the free legal aid, and especially for Bihar, the court was saying you must provide free legal services for the accused who are unable to have a lawyer, and when the charged offence could result in imprisonment or the case circumstances and the social justice needs justify legal representations. The court further says that there might be some exceptional cases like crimes in which there are economic offences, the crimes relating to prostitution, child abuse, social injustice, in which there is no need to provide free legal aid, but when the people are suffering from poverty, then the free legal aid becomes a necessity, and this was the obligation of the court, the judges of the court, the magistrates and the sessions judges. They must inform the accused if they are unrepresented due to poverty. There was also another case which is a landmark named Sukhdas, and you know this was the case in Arunachal Pradesh, and in the northeast region of our country. What happened, that again a person whose services were terminated, and therefore, his petition was filed, and in that case the Supreme Court ruled that the exercise of the right to free legal aid cannot be denied if the accused fails to apply for that, because that person was also because of the reasons that he was poor, he could not afford to have a lawyer to fight his case, and therefore, he was also suffering from this kind of problem in jail, that okay, he will not be released. Now, when the matter was in the court, then the court looked at the person that he is unrepresented, but the court did not do anything. But the Supreme Court says that no, this should not have been the case. There is no need that a person will apply for it, because then the argument was he did not apply for the free legal aid. So, the court was saying it is not needed that the person who has come to the court unrepresented, he or she will first of all apply, and then that counsel can be appointed for that. It is not the need, it is the duty of the magistrate, it is the duty of the sessions judge that they would inform the person that you can have the legal aid if they know that the person is poor. And therefore, the court was saying, observing that approximately 70% of the rural Indians are illiterate and they are unaware of their legal rights. Even the literate often do not know that what are their legal entitlements. Therefore, it is not always essential that they will have to first of all apply and then they will get any kind of representation. Poverty and helplessness, the court was saying that the legal awareness among the poor is very low. That leads to exploitation and deprivation of rights. Therefore, if there would be legal aid which will ensure that these people will receive protection and justice. And the court reiterated the principle which was laid down in Khatri versus State of Bihar, that the magistrates and the sessions judges must inform the accused of their right to free legal services if they cannot afford a lawyer. So, a lesson that we learn from this case of Sukdas, that legal aid must be proactively offered to indigent accused to avoid making it a mere paper promise. So, these are some of the early cases. We have tried to understand these 2-3 cases in the early 80s and late 80s, so that we will learn that how this constitution which was there, the amendment was made in the constitution, and the court was also giving lot of directions. The court was also making efforts that how this constitutional promise that can be fulfilled on the ground. But here the role of the lawyers can also be highlighted, that how the lawyers took up the cause of the poor, and then the role of the judges cannot also be underestimated. Justice P. N. Bhagwati took up this problem and highlighted and gave appropriate directions for justice. And you see that Supreme Court itself started doing something. It tried to constitute a committee for implementing legal aid schemes all over the country, and from there the evolution of the legal aid, institutional legal aid, that started. The court established in 1980 the Committee for Implementing Legal Services, in short we will call it SILAS, and it was formed by Justice P. N. Bhagwati. He was the chairperson, and he said that this committee will try to implement the legal aid schemes, and it provided legal aid camps. It formed legal aid and advice boards nationwide, and it identified limitations also in the functioning of SILAS, and thereafter it prompted the need for statutory legal service authorities at national, state and district level. Justice P. N. Bhagwati himself went to different states, particularly he was interested in looking at the traditional dispute resolution mechanisms which were going on, and he saw himself with his bare eyes that at those places people go to the place and they know that the dispute can be resolved. And he also tried to understand the panchayat system, how the panchayat system was resolving the case, and he wanted to formalize it. He wanted to say that, you see, how can the dispute resolution which was informal in those places, that should be formalized, that should be given a kind of support from the institutions, government institutions. And therefore, what happened, that Supreme Court itself went and provided legal aid, because the Supreme Court judges had the powers to formalize it. And therefore, what happened, that those judges in those times, they did not just sit in the Supreme Court, but they also try to travel, look at the problems on the ground and try to learn from those experiments. So, what happened that when the Silas was working, Silas wanted to recommend to the government that let us have a recognition to the traditional kind of legal services which were given, and that will be very helpful in providing access to justice to the common people. And therefore, the court was saying that there is a need of having strategic legal aid programs, and the court says that legal literacy is also very important. People are not literate about their rights, therefore, legal literacy should also be included in the legal services. And he also says that the role of voluntary agencies are also important, because unless and until people will voluntarily do something for the poor cannot get access to justice. And therefore, what happened that the Legal Services Authorities Act was passed. You can now understand that there have been several steps, there have been several stages in which the whole kind of opinion was being formed all over the country, that apart from the rigid court structure which has been there, there should be some kind of different type of a structure in which the poor people can have access, and in the court also, in the formal court also, the poor people can have access easily, and that should be also done. So, there was in the earlier criminal procedure code, section 304 was there, and section 304 was saying that legal aid can be provided, but it was not working properly. And therefore, what happened that in 1987 Legal Services Authorities Act was passed. Now, this new act, Legal Services Authorities Act, that is very important, and you will find that the Legal Services Authorities Act is one of the important pieces of legislation which must be learned whenever you have time. You can learn the provisions of the Legal Services Authorities Act, but I will also tell you that before this Free Legal Services or Legal Services Authorities Act that was passed, there were some Law Commission of India's recommendation also. So, every institution was working to develop this jurisprudence of liberalizing the rule of locus standi and promoting the cause of public interest and the public interest litigation, and therefore, Law Commission of India's role should also be highlighted. There were the Law Commission of India's report, 14th report, which recommended that there must be legal aid from the state, and which emphasized the need for financial assistance to ensure equal justice. There was the 41st report of the Law Commission, which advocated government funded legal representation in all courts and the sessions trials. The 48th report also suggested free legal assistance for all accused unable to afford a lawyer. So, you see that Law Commission of India also was giving reports to the government recommending that legal services should be free to the poor people. And the new law also, BNSS, Bharatiya Nagrik Suraksha Sanhita, section 303, that provides that any accused person has the right to be defended by a lawyer, but there is no obligation on the courts to assign a state funded pleader. So, even though there is no obligation as such, the state can't be sued that a person was not provided counsel even if the person is poor, but at the same time the law recognizes the right to be defended. by the person who is there in the court, in the sessions court, in the magistrates court. That person has the right, but this right does not have the claim that he or she can sue the state. And we will also see that there are certain rules which are made by the high courts, by which the pleaders can be selected, and the appointment of pleaders can be facilitated, and the payment of fees by the government can also be done. So, we can see that the Bharatiya Nagrik Suraksha Sanhita also has provisions. So, the law, so the institutions, various institutions, they all work together and a new jurisprudence evolved. So, what we can see that the Legal Services Authorities Act, which is a very important piece of legislation, you will find that certain people are entitled to legal aid, and section 12 of the Legal Services Authorities Act, that is very clearly laying down that who are those persons. And if you look at the Legal Services Authorities Act, you will find that women, children, person who is having this income, and the income is given in the act that initially it was 12,000, now it depends upon the state government, that the state government can increase according to the economic capacity. And if a person falls below that criteria, that what is the earning of that person, then what can happen, that a person can be entitled to get free legal aid, and there will be the help of the state. So, this section is also very important. Apart from that section, in the Legal Services Authorities Act, you will find that several institutions have been created, like National Legal Service Authority has been created, which is in short can be called NALSA. Likewise, State Legal Service Authority has been constituted, and at the district level also district legal service authority has been constituted. So, even there is a provision in the Legal Services Authorities Act that there should be also a legal service authority at the taluka level, at the subdivisional level, but this has not been there. This is not fully functional in all over the country. However, the district legal service authority, the state legal services authority, the national legal services authority, those have been constituted, and now they are doing a very good job. You must also know that the National Legal Service Authority Act, that was enacted in 1987, but it took a long time for it to be implemented. You see, in 1995 only it was implemented. So, in the last 30 years, this after the implementation of Legal Services Authorities Act, we can now see that this NALSA and the State Legal Service Authority, the District Legal Service Authority, they are doing wonders to provide the legal aid. I have many friends who are judges in the different district courts of our country, and they constantly tell me that yes, they are providing legal aid to the poor, and many of them, they are in the District Legal Services Authority. So, what I was telling you, that the National Legal Service schemes, that is very important, and Legal Service Authorities Act, that you must always learn. In the Act, there is also provision for having Lok Adalat. Now, what is this Lok Adalat? Lok Adalats, I told you that the SILAS, the committee to implement the schemes, legal aid schemes, the Supreme Court had gone to several places to understand the dispute resolution mechanisms, different alternative dispute resolution mechanisms. Now, the alternative dispute resolution mechanisms which were working already in our country, those were not formalized. He looked at the mediations being provided. Some mediators, like the Mukhya of Gram Panchayat, the Sarpanch of the Gram Panchayat, or sometimes even informally some people whom some people will trust, they will resolve the dispute acting as the mediator in such cases. So, when the Silas understood this mechanism, they also recommended that in the act there should be such system of which will formalize such kind of award or decision. And you see, the Supreme Court studied the various alternative dispute resolution mechanisms and try to understand, and you know what, that in fact there are different alternative dispute resolution mechanisms. For example, negotiation, for example, mediation, for example, conciliation, and arbitration and settlement of a dispute through the courts. So, when the Supreme Court was trying to understand this, it came to understand that mediation was being provided, and mediation and some sort of conciliation. Now, what is the difference between mediation and conciliation? You must know, because being a student of jurisprudence, the concepts, the basic concepts must be clear. And what happens in mediation, that the parties who are having dispute, they could not resolve their dispute themselves. Therefore, what they are doing, that they appoint a neutral third party in whom they have faith, but the neutral third party, he or she will go to look at the laws passed by the parliament. What the mediator can do, that mediator can just give a right atmosphere to the parties, again that so that they will be able to talk to each other, they can negotiate with each other, so that there can be some resolution of the dispute. And once that dispute is settled, the mediator says that okay, I am also a witness that you have settled the dispute in this way. So, this was the mediation, but then there is another stage which is little bit higher than mediation, which is called conciliation. Now, in conciliation what happens, that two parties who are having the dispute, now again they could not resolve their disputes themselves. So, what they were doing, that they appointed a neutral third party, and not only that, neutral third party provided the right atmosphere for the litigants, for the persons having dispute to sit together and discuss. But what in this case will happen, that the conciliator will be given right to also inquire from the parties that what is the real fact of the matter. And after the inquiry, what happens, that the conciliator can give his or her solutions, recommendations, that okay, because I have found that the exaggerated claim of the parties, those are not true, and the fact is this, on this basis you can now resolve the dispute. And if you are not able to resolve the dispute on the established facts, then what I will do, that I will also give you some recommendations. Now, the recommendations which are given to the parties, they should be accepted, and if they accept, then the conciliation is called successful. So, this was the situation, this was the conceptual understanding, this was the jurisprudence prevailing in the ADR, particularly in mediation and conciliation. But when this was adopted in the Legal Service Authorities Act, there was a slight change, and the change was that the Legal Services Authorities Act provided that there will be now Lok Adalat, and Lok Adalats would work on the basis that if there is a trial going on in the court for offence, and the offence in question is a compoundable offence, then if the parties want, the case can be referred to the Lok Adalat. And the court was also given the power that why not, because the courts are already burdened with lot of cases, there are areas in the courts. So, the court was also given the power that compoundable offences should be first of all going to Lok Adalat, so that there can be a possibility, there should be exploration of the possibility that the dispute would be resolved through the Lok Adalat in a quick manner, because Lok Adalats are flexible. Lok Adalats are not bound by the Criminal Procedure Code or by the Indian Evidence Act, and therefore, what will be the case in Lok Adalat, that in Lok Adalat there is no need of advocates. So, parties can directly negotiate in the presence of the court, the judges, and who are the members of the Lok Adalat? There will be people from the court, there will be people from the NGOs, and there may be another neutral person who can be appointed. So, this will be fairly not just court system, but this is a kind of different system in which there is a greater possibility that the dispute would be resolved quickly, because there is no hard and fast rule that evidence law, CRPC law will have to be followed. And if the parties agree that this will be the accepted thing, we will accept the findings of the Lok Adalat judges, then what will happen, that there will be award. This is called settlement award, and there will be award which will be binding on the parties, and there is no provision for appeal. You might have heard about the court system in which tarikh par tarikh, appeal par appeal goes on, but this system of Lok Adalat, there is no such thing, tarikh par tarikh and appeal par appeal. There is no tarikh in the Lok Adalat system. In Lok Adalat system, there will be one tarikh, and in that tarikh, if you go, you can settle your problem there only. And there is no appeal system, because once you accept the verdict of the Lok Adalat, this will be final and binding on the parties. So, this Lok Adalat also was has been inserted, and Lok Adalats are organized on a regular basis by the National Legal Service Authority, and by the State Legal Service Authority, and by the District Legal Services Authority. And this has helped lot of litigants all over the country to get access to justice, because this access to justice has been a core value in the last 75 years of the working of the Constitution. This core value that there has to be greater access to justice. There should not be hindrance to get justice because a person is poor. And Lok Adalats have also done very well. And what about the legal status of Lok Adalat? You know what, that when the legal Lok Adalats were constituted, and the lawyers thought that they would not have any job there in the Lok Adalats, they started opposing this Legal Service Authorities Act vehemently, and several challenges were filed in different courts of our country. However, the Supreme Court came to the rescue of the law, and Supreme Court said that there is no constitutional problem in this law, and Lok Adalats therefore was recognized. This was a system of faster and cheaper justice, which was effectively handling the diverse disputes, and especially the compoundable criminal complaints, civil cases, revenue disputes, motor accident claims tribunal, and cases involving some institutions. So, what we find that the Lok Adalats have been also working very well, but a problem was found in the Lok Adalats. Why? Because when a case is referred to the Lok Adalat by the court, and suppose the Lok Adalat starts hearing the parties, and what happens that Lok Adalats try that the case may be settled, and there will be a settlement order passed by the Lok Adalat. However, suppose for any reason, because this is the necessity that the parties will give consent to the settlement order. If the parties, one of the parties will not give consent to the settlement order, then it will not be the successful mediation or conciliation by Lok Adalat. and it will fail, and the matter will again be diverted, means reverted back to the court. So, this is kind of in Sanskrit we say punarmushiko bhava. So, again the situation, the complaint which was being heard by the court and which came to the Lok Adalat again will go back to the court, and fir tarikh pe tarikh and fir appeal pe appeal. So, that will be the case, and therefore, the situation will be the same. And therefore, to avoid such situation, what happened, that the Legal Service Authorities Act was amended, and in the year 2002 this amendment was to the effect that there will be constitution of permanent Lok Adalat. Now, permanent Lok Adalats have been also constituted in the field of public transport, electricity distribution, and telephone and insurance, in these postal services, in these areas, these kind of permanent Lok Adalats have been established. And you know what, the permanent Lok Adalats, they will do the Lok Adalat in a way that it will not fail, because the parties are not given choice to withdraw the consent, and it will, suppose if the parties will say that okay, we will not be flexible, then this will be like a court, this will work like a court. So, permanent Lok Adalat is a mixture of the court system and the original Lok Adalat system, where the one of the parties that can just torpedo the whole ship, but in the permanent Lok Adalat system there will be no such possibility, and the person who goes to permanent Lok Adalat will definitely get a relief. Even then there is no place for appeal in permanent Lok Adalat also. So, if a matter goes to permanent Lok Adalat, there will be no provision that you can go in appeal to the district court or the high court or the Supreme Court. So, many lawyers, they started saying that how can this be, this is a substandard justice, because there is no appeal system. If a party is not happy with the order, then the appeal will not lie, and this will be inferior kind of justice. But this was not right. The courts have upheld that this was the party choice, and because there are pendency of cases and the people are poor and they cannot afford a lawyer, there is no system that okay, again this matter will go in appeal, and whatever is the effort of the Lok Adalat judges, those efforts are very good. It has not been seen that substandard or inferior kind of justice is being delivered by the Lok Adalats, but yes, there is no system of appeal from the Lok Adalats. And therefore, the public participation in the legal aid programs, that has been increasing, and I remember that when I was a student of law in Delhi University, I had participated in one of the first legal aid Lok Adalats, which was organized by our university law faculty, and I had seen that how it was difficult at that moment of time to convince the litigants to come to the Lok Adalat. However, in the last 30 years, I have seen that how this public participation is increasing. Now, people are aware of the organization of Lok Adalats in their towns, in their cities, and particularly I have seen that most people go to Lok Adalat to settle the traffic challans, and traffic challans normally would have gone to the traffic court, but if it is going to the Lok Adalats, what will happen, that this will be settled in a day. And likewise, there are many motor accident claims which go to Lok Adalats, and motor accident claims are also settled very quickly. So, the public participation in the legal aid program is important, and this was also held by the Supreme Court in the Center of Legal Research versus State of Kerala. The court emphasized that public participation is crucial for the success of legal aid programs. The bench and bar role, I have tried to highlight the role of the bench and bar. I told you that how judges in the late 70s and early 80s onwards, they have been doing it, and their role should not be underestimated. The role of the bar also has been very crucial. I told you about Kapila Hingorani. I told you that how the different bar associations, they are also helping the poor people by voluntarily giving free legal services. And therefore, you see at the international level also the judicial sensitivity has been infused, and the role of the bar should be that they will not be so critical of the legal aid schemes, because this is a new jurisprudence. When this will be misused, then they have definitely a role in saying that no, this is not going to be properly used, this is being misused. However, the legal professionals, they have lot of work to do in the courts, and therefore, there is an important role of the bench and the bar in the legal aid. So, we have seen in this whole lecture that what is the importance of the principle. We have been telling you that the jurisprudence of our country is developing in a unique way, and one of the unique developments has been the institution of public interest litigation. This is not there in many other countries. Even in the developed countries, you will not find the public interest litigation, and this public interest litigation in the field of legal services has heralded a new jurisprudence, and we have seen that legal aid schemes which were started by the Supreme Court and thereafter which was institutionalized by enacting a legislation, Legal Services Authorities Act of 1987, which was implemented in 1995, and from then onwards you can see that lot of activities by the Lok Adalats and by the National Legal Services Authorities Act, by the State Legal Services Authority Act, and by the District Legal Services Authorities Act, District Legal Services Authority. What you can see that they are doing lot of works to provide justice to the poor people. Gone are the days when a poor person will say that I do not have access to justice, but yes, legal awareness is also important. If the person will not know that where to go, where not to go, so legal awareness is very important. This is the strategic legal aid program, that when the legal aid programs are going on, there must be one component of legal awareness of the common people. There should be the new applications which must be there and which can be installed on the mobile, so that the people can know about their legal rights and they may be aware. So, only then our country's jurisprudence will change, and we will have new kind of legal system in which there would be a court system, and in parallel there will be the Lok Adalat system going on, free legal services will go on. So, I hope that you have understood this. Thank you so much for your kind attention. I hope that we will meet again. Thank you.